Good morning, students. This is our third online class. I hope you all are safe with your families as following the advices of the government. As in our second online class, we are going to discuss about the fundamental rights and directive principles of the state policy and fundamental duties. So, this is our second chapter of civics. So, I want to ask one question. Do you know about the fundamental rights? Do you know why these are included in the constitution? So first of all, let me tell you that the fundamental rights are the founding features of the Indian constitution. As we are aware of the need to recognize people's basic rights and to protect them from aggression of executive and the legislative wings of the government. The constitutional guarantees to such fundamental rights is indispensable for maintaining state's democratic nature. Hence, constitution makers included separate chapter under part 3 of Constitution Fundamental Rights. The core of the Indian Constitution lies in part 3 that relates to the fundamental rights. The right had 3 deep roots in the struggle for the independence. Part 4 of the Constitution lays down the directive principles of the state policy. As you can see on the screen, the core of the Indian Constitution lies in Part 3 and the directive principles of the state policy lies in Part 4. So today we are going to learn about the fundamental rights. So as you can see it on the screen, the rights guaranteed under the Indian Constitution are fundamental in the sense that they have been incorporated in the fundamental law of the land. The fundamental law of the land describes you about that the land, the law and regulations as maintained in the Constitution are considered as the fundamental law of the land. This is because no central, state or local government can intervene with the rights, duties, privileges, laws and regulations as mentioned in the Constitution. As you can see, the word absolute. Yes, rights are those absolute or uncontrolled rights. They are not fundamental in the sense that they are absolute. An absolute or uncontrolled right may lead to a state to complete disorder or lawlessness. Neither are the rights free from constitutional amendment. Rights changes with the time and situation. As you can see, on 10th December 1948, UN General Assembly adopted the Universal Declaration of Human Rights. Since then, every year, December 10th is celebrated as the Human Rights Day all over the world. The UN called upon all member states to adopt 3 rights in their respective constitution. Indian Constitution Affairs adopts and enacts human rights. So in this way, we'll come to know that it can be enjoyed by all, but these rights can be regulated by the judiciary. They may be suspended by the president during emergency. These rights are justiciable. Citizens are approach the judiciary when they are violated. They are applicable to all citizens. So in this way, we will come to know about the fundamental rights. We will learn about the significance of the rights. The significance of the rights and why these are included in the Constitution. The purpose and the significance of the fundamental rights and reasons for their inclusion in the Constitution are as follows. So you will see the different points related to the inclusion of the Constitution, the inclusion of the fundamental rights in the Constitution. First point tells you about right shape human personality. It describes about that rights are essential for the development of the powers inherent in every individual. They are secured to preserve human dignity and to promote social progress in larger freedom. And second point describes about the democracy implies civil liberties. Democracy is meaningless if civil liberties such as freedom of speech, freedom of religion, and freedom from unreasonable arrest are not protected by the state. The Constitution of India guarantees to the citizens freedom of speech, freedom of assembly, freedom of religion, and the right to form associations or unions. If a person is availing all these facilities, so it describes that it is a democratic country and a person is free from all the liabilities, all the things which he wants to do. Rights are a check on unjust acts of the government. This is a third point. The fundamental rights can be altered or curtailed only by an amendment to the Constitution. Thus, their inclusion is a check not only on the executive, the President, the Prime Minister, ministers and the government officials, but also on the Parliament and other legislative bodies. Our fourth point tells us about the rights are enforceable by the courts. All persons, irrespective of race, religion, caste, or sex, have the right to move the Supreme Court or the High Court for the enforcement of the rights conferred by Part 3 of the Constitution, means related to the fundamental rights. In the public interest, anyone can commence litigation in the court. This is known as the public interest litigation. Means we can approach to the court if we are violated by any organ of a government. Then, do you know about the important features of the fundamental rights? The important features of the fundamental rights are as follows. It describes in the following terms. The first term is about inclusion all authorities within the territory of India. The purpose of fundamental right is to impose checks on state and establish a limited government. Therefore, the term state includes the government and the Parliament of India and the government and the legislature of each of the state. It also includes all local or other authorities such as the municipal corporation, municipal board, district boards, panchayats, state electricity board, airport authority, port trust, and so on. Now we have a next point, that is, some rights are available to all persons, others are available to citizens alone. In this we can see that few rights are here for the citizens of our country and few rights are here only for the outsiders. Rights to life or personal liberty is available to all persons. Likewise, all persons are entitled to freedom of religion, but such freedoms as freedom of speech and expressions and freedom to reside and settle in any part of the country are secured to citizens alone. Means any foreigner or a person who is not the citizen of India is not entitled to reside in any part of the country. They can come and visit our country and they have to go back to their own country. Our third point describes about the rights protect individuals against state action as well as the action of the private citizen. Some of the rights are enforceable against private citizens also. For instance, the Constitution abolishes untouchability. The untouchability is a social evil of our country, and if any person or a community is forcing any individual or a group, so they will be punished by the court. Therefore, persons practicing untouchability shall be punished. Our fourth point describes about rights are not absolute. Like The state is the custodian of the general public interests, decency or morality. Therefore, state may make laws putting restrictions on our rights. Our fifth point describes about right may be curtailed through constitutional amendments. All provisions of the Constitution, including those concerning the fundamental rights, can be amended. The Parliament, however, cannot alter the basic structure of the Constitution. Most judges believe that features such as the secularism and democratic government definitely fell in that category. The sixth feature describes about during the proclamation of the emergency, many rights remain suspended. A proclamation of emergency shall have an adverse effect on fundamental rights. Firstly, right conferred by Article 19, freedom of speech, freedom of assembly, freedom of movement, etc. remains suspended. So these rights can be taken away by the citizens of India if there is any emergency applied by the President of India in our country. In other words, the legislature may make laws or the executive may commit acts which go against the rights conferred by the 19th. Secondly, the President may by order suspended the right to move the court for the enforcement of the other rights. So in this way we'll see and we had learned about the important features of the fundamental rights. Do you know, children, about the different categories of the fundamental right? So the fundamental rights are grouped under 6 main categories. Right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. So I'm going to explain to you about the first right to equality. Right to equality is subdivided into different categories. So, Indian Constitution makes equality as the bedrock of Indian polity. So, in this way, it is divided into different categories. As the first point describes you about equality before law. Article 14 guarantees to every person equality before the law or the equal protection of the laws within the territory of India. The Constitution forbids discrimination between persons placed in similar circumstances or conditions. Our second point describes about the prohibition of discrimination. Constitution prohibits the state to discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth or any of them. No citizen shall be denied use to shops, public restaurants, hotels and places of public entertainment. Neither shall anyone be denied the use of wells, tanks, bathing ghats and roads maintained wholly or partly out of the state fund. So we all are free to avail all the facilities provided by the government to us. There are, however, 2 notable exceptions to the right. First, the state may make any special provision for women and children. Second, special provisions may be made for the advancement of any specially and educationally background classes of the citizens or for the scheduled caste and the scheduled tribes. So, these are the 2 cases for women and children and for scheduled caste and scheduled tribes. there may be some separate laws. Third point describes about equality is that equality of opportunity in matters of public employment. Constitution lays down that there shall be equal opportunity for citizens in matters relating to employment or appointment to any office under the state. Now there are 3 points through which a person gets the employment. The first one is the Parliament may make laws prescribing any requirement as to residence for state employment. This is meant for posts which require a knowledge of the locality and of the language of the area. So in this point, the person should know the locality as well as the language of that place. Second point, the state may reserve posts for members of any backward class which is not adequately represented in the services under the state. So the second point is for the reserved seat for the backward classes. The third point describes about that a law which requires that the holder of an office of any religious institution shall be a person professing that particular religion. Means the person should be well aware of that religion of which he is going to establish or running an office. The purpose behind the reservation policy of scheduled caste and backward classes is to bring the weaker sections to the level of the advanced sections of our society. Now, in fourth point, we will see abolition of untouchability. Constitution declares that untouchability is abolished and its practice in any form is forbidden. The Untouchability Offence Act of 1955 provided penalties for preventing a person from entering a place of public worship or taking water from a tank, well or spring. Penalties are also provided for denying access to any shop, hotel or restaurant. In 1976, the name of the act was changed from Untouchability Offence Act to the Protection of Civil Rights Act. Abolition of titles. Article 18 of the Constitution prohibits the state from conferring any titles except military or academic distinctions. Citizens of India cannot accept any title from a foreign state. The British government had created a peculiar class of aristocrats known as the Rai Bahadurs or Khan Bahadurs in India. These titles were abolished because they went against the principles of equality of status. These titles show a difference between equality. People, those who are holding these titles like Rai Bahadur, they were considered as the high class. And people, those who don't have these titles, they were considered as low class. So these titles were abolished as they were not following the principles of the equality of status. However, the award of Bharat Ratna or Padma Vibhushan says D.D. Basu cannot be used by the recipient as a title and does not accordingly come within the constitutional prohibition. So in this way, we had learned about the first category of the fundamental rights, equality before law. Our second category of the fundamental rights is the right to freedom. Democracy presupposes not only equality, it also calls for individual liberty. There are 6 freedoms: freedom of speech and expression, freedom to assemble peaceably and without arms, freedom to form associations and unions, right to move freely, freedom to reside and settle in any part of the country, right to practice any profession or to carry on any occupation. So these are the 6 freedoms, and the first one explains you about freedom of speech and expression. Freedom of speech and expression enables us to participate in public activities. The words freedom of this press have not been used in Article 19, but freedom of expression also includes freedom of the press. Reasonable restrictions on the right can be imposed in the interest of public order, security of the state, decency or morality. Second one describes you about the right of assembly is subject to 2 limitations. First, it is to be exercised peacefully, and secondly, without arms. Further, the state may impose reasonable restrictions in the interest of public order or the integrity of India. A third point describes about freedom to form associations and unions. The citizens have the freedom to form associations or unions. The state may impose reasonable restrictions on this freedom in the interest of morality, public order and integrity of India. Our fourth point describes about right to move freely. We are free to move anywhere in our country, but following the fundamental duties. The citizens have the right to go wherever they like in the territory of India. However, reasonable restrictions may be imposed in the interest of the general public. Thus, restrictions may be imposed on movement and travelling so as to control an epidemic. Fifth point describes about freedom to reside and settle in any part of India. This freedom is also subject to reasonable restrictions in the interest of the general public or for the protection of the interest of the scheduled tribes. Otherwise, tribal people may become easy victims of the exploitation. So in this way, the backward people, the scheduled caste people, have a right to settle in any part of the country. Our sixth point describes about right to practice any profession or to carry on any occupation. All citizens have the right to practice any profession or to carry on any occupation, trade or business, but the right is subject to certain exceptions. First, the state may impose reasonable restrictions on the right in the interests of the general public. Thus, there is no right to carry on a business which is dangerous or immoral for the society. Second, professional or technical qualifications may be prescribed for practicing any profession or carrying on any trade. So these 6 freedoms comes under the category of right to freedom. Now, there are few other subcategories which comes under the right to freedom. That is the protection of life and personal liberty. It describes in Article 21 that no person shall be deprived of his life or personal liberty except according to the procedure established by the law. In third point, we will see rights of persons arrested under the ordinary circumstances. Constitution confers 3 rights upon a person arrested under the ordinary circumstances. The first one, no person shall be denied in custody without being informed of the grounds of such arrest. Means the person has a right to ask from the law that why he was arrested. Then second, he shall have the right to be defended by a lawyer of his choice. Third, he has the right to be produced before the nearest magistrate within 24 hours of such arrest. The above safeguards are not available to an enemy alliance. What is this enemy alliance? An enemy alliance is a native, citizen or subject of a foreign nation or state. Means for the foreign enemy, for the foreigner, all these rights are not applicable. These rights are applicable only for the citizens of our country. Neither shall these rights apply to person denied under the Preventive Detention Act. So, a Preventive Detention Act tells you how a person can save himself. Preventive detention is detention of a person without trial. The object of preventive detention is not to punish a person for having committed a crime but to prevent him from doing so. This is not a punitive but a precautionary measure. The Constitution gives these rights to a detainee. Detainee means one person who is caught by the law. Then the first one tells you about no one shall be denied for a period longer than 3 months. This period can be extended only by an advisory board. Only those persons who are judges of the High Court or are qualified to be appointed as judges shall be the members of the board. Second, the preventive detention law should lay down the maximum period of detention for a detainee. Third, since the advisory board has to examine whether detention is permissible beyond 3 months or not. The detainee has 2 more rights, namely the right to know the ground on which he has been detained, the right to make a representation against the detention order. So this is the preventive detention. According to these rules, he can save himself from the law. How to educate. This is another feature of the right to freedom. The Constitution 86 Amendment Act 2002 inserted a new Article 21A. After Article 21A, this new article deals with right to education. It says the state shall provide free and compulsory education to all children of the age 6 to 14 years in such manner as the state may by law determine. The Right to Education Act comes into force on 1st April 2010. This was a historic day for the people of India, since from this day the right to education was given the same legal force as the right to life under the Constitution of India. The right to education seeks to provide education to all children aged 6 to 14 years. It also reserved 25% of the seats for weaker sections of the society, even in the private and minority schools. Any expansion that prevents a child from going to school will be borne both by the center and the state. So in these terms, we had learned about this right to freedom. One more point, as we can see it on the screen, right to information of 2005. The Parliament enacted the Right to Information Act in 2005. This right enabled citizens to secure information from public authorities, government offices, financial institutions and public sectors undertaking in respect of documents and records under their charge. This right could be curb corruption and promote transparency in government department. On 12th January 2009, the Delhi High Court ruled that the right to information was a fundamental right. Even the Chief Justice of India was covered by the right to information. So this is a right through which we can approach to the court and inform about the higher authorities. Okay, so this is the last point which comes under the right to freedom. Before it was not under the right to freedom, but it was included in the constitution in 2005. So now our third category is right against exploitation. The constitution includes two main declarations against the exploitation. The first one is prohibition of traffic in human beings and forced labor. It describes about that constitution prohibits traffic in human beings and beggar and their similar forms of forced labor. Traffic in human beings means dealing in a men and women like goods, such as selling, letting or otherwise disposing of them. It would include traffic in women and girls for immoral purpose. Beggar or forced labor means making a person work against his will and then not to pay him with his wages. Payment of less than the minimum wages has been held as forced labor by the Supreme Court. Exceptions. An exception is made for compulsory services for public purposes. Compulsory military conscription is covered by this provision. A second point describes about prohibition of employment of children in factories, etc. No child below the age of 14 years shall be employed to work in any factory or mine, nor shall such a child be engaged in any hazardous employment. So in this way, the child labor is not at all allowed by the right against exploitation. If any child is exploited, his parents or he or she herself has a right to approach to the court. Our fourth point describes, or the fourth category describes about the right to freedom of religion. The preamble to the Constitution secures to all citizens liberty of belief, faith and worship. This objective is achieved by the following provisions of the Constitution. The first provision is freedom of conscience and free profession and propagation of religion. Constitution guarantees of every person freedom of conscience and the right to profess, practice and propagate religion. The wearing and caring of kripans is included in the profession of the Sikh religion. But in the interest of morality, health and public order means it should not disturb the peace of the nation and the public. A second feature which comes under the category of right to freedom of religion is freedom to maintain religious affairs. Constitution guarantees the right to establish and maintain institutions for religious and charitable purposes. Every religious sect has the right to own and acquire movable and immovable property. Third point describes about freedom as to payment of taxes for promotion of any particular religion. No taxes shall be levied the income from which it meant for the maintenance of any particular religion. It is against the ideals of the secular state to pay out of the public funds and money for the promotion of any particular religion. Fourth point describes about no religious instructions in institutions maintained out of state funds. There is a distinction between educational institutions wholly maintained out of state funds and those recognized by the state or receiving aids out of the state funds. No religious instruction instructions shall be provided in any educational institutions wholly maintained by the state fund. As regarded state-aided or state-recognized institutions, there is no check on giving religious instructions, but no person can be required to take part in any religious instructions unless such person gives his consent, or if he is a minor, consent of his guardian as has been obtained. The Constitution thus aims to establish a secular state. It allows equal freedom of faith and worship to all. So these are the points which comes under the right to freedom of religion. Now our fifth point describes about the cultural and the educational rights. In this we have different subcategories. Protection of the interest of the minorities. India is a country which is a museum of different cultures and religions. Hence it was but natural that the constitution should have protected cultural and educational rights of the minorities. As we have already discussed about minorities in the first chapter, so the first point describes about right to conserve the language, script and culture. Minorities have a right to conserve their distinct languages, script or culture. Such minorities shall not be denied admission into the educational institutions maintained or aided by the state on grounds only of religion, race or language. Second point describes about right to establish educational institutions. Minorities have the right to establish and administer educational institutions of their choice. In guaranteeing aid to the institutions, the state shall not discriminate against any institution on the ground of that it is, but the state can issue guidelines for ensuring the security of the services of the teachers or other employees of the institution. The Supreme Court ruled that in the case of aided minority institutions offering professional courses, admission could only be through a common entrance test conducted by the state or some university. Even an unaided minority institutions ought not to ignore the merit of the students for admission. Means only the particular religion children will not get the admission, but other children, those who belong to another religion, they will also get the admission on the basis of their merit. Our sixth category describes about the right to constitutional remedies. A big declaration of the fundamental rights is useless unless there are the means to make them effective. Article 32 guarantees the right to move the Supreme Court of the enforcement of the rights conferred by Part 3 of the Constitution. The Constitution empowers the High Courts also to issue writs or orders for the enforcement of any of the rights. The writ is a legal document ordering the performance of some action. Writs act as the check on arbitrary actions of the state. So, the first writ describes about the writ of the habeas corpus. The habeas corpus is a Latin term which means you may have the body. It provides a remedy for a person wrongly detained or restrained. The Supreme Court and the High Court issue this writ to a person who detained another in authority and command him to bring the person to the court and tell the time and the case of the arrest. If the cause is insufficient, he is at once unconditionally released. Second writ is the mandamus. The Latin term mandamus means we command. The purpose of The writ is to compel an inferior court to an individual to perform their duties. This power has to be exercised only for the enforcement of the fundamental rights. Our third writ is prohibition. A writ of prohibition is issued to prevent an inferior court from exercising powers with which it is not legally vested. It directs the inferior court to keep within the limits of their authorities. Certiorari is the fourth writ. The term certiorari means to be informed of what is going on. By this writ, the lower court is asked to hand over the record of a particular case to the higher court. Our fifth writ describes about writ of quo warranto. This writ is directed against a person who has wrongfully adopted an office. The writ calls upon the person to show under what authority he holds the office. If the court decides that the person concerned is holding that office illegally, it may declare the office to be vacant. So these are the 5 writs, in which the first writ, habeas corpus, describes about you may have the body. It provides a remedy for the person. Second writ describes about mandamus, which is a Latin term which means we command. Third writ describes about the prohibition is issued to prevent an inferior court from exercising powers. Fourth writ describes about certiorari, which informs the lower court is asked to hand over the records of the particular case to the high court. And in fifth, quo warranto describes about when a person holds the office without the permission of the government, then it may declare the office to be vacant by the government. So these are the 5 constitutional remedies given by the declared by the Supreme Court and the High Court to us. Now, the last point, which describes about the right to property, which ceases to be a fundamental right. The original constitution provided for the right to property under Article 19 and 31. The provisions related to right to property were controversial. Therefore, the 44th Amendment Act 1978 deleted the right to property from the list of fundamental rights. A new Article 300A was added to the Constitution, which provides that no person shall be deprived of his property save by authority of law. Thus, the right to property is no longer fundamental right, though it is still a legal right. If the government acts unfairly, the action can be challenged in the court. So I hope you all have learned about the 6 categories of the fundamental right. Once again, we will do the revision of the topics. The first one was the fundamental right, which lays down in part 3 of the Constitution. We have the meaning and the why it was included in the Constitution, the fundamental rights, that is, the right guarantees under the Indian Constitutions are fundamental in the sense that they have been incorporated in the fundamental law of the land, the Constitution, and can be enforced by the court. Then we have significance of the rights and the reasons for their inclusion in the Constitution. So rights shape human personality. Democracy implies civil liberties. Rights are the check on unjust acts of the government. Then rights are enforceable by the courts. After that, we have learned important features of the fundamental rights. In that we had learned about the first term is the state includes all the authorities within the territory of India. Some rights are available to all persons, others are available to citizens alone. Rights are not absolute. During the proclamation of emergency, many rights remain suspended. After that, we had learned 6 categories of the fundamental rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. So, I hope you have listened the video carefully, and I have given you one assignment related to these topics. Please complete the assignment. Write all the answers in your history register and bring it to school when it will be reopened. Thank you.